My name's Christina Smith. For those of you who may not know me personally, I'm going to conduct the sexual harassment and abusive conduct prevention training. I do this every year. It's everyone's favorite time of year, including myself. So we'll go ahead and get started. So the purpose of this training is to review the elements of discrimination, sexual harassment, and other forms of harassment. We're going to be discussing the remedies available to victims of harassment under both California and federal law, which is helpful to know both as employees and as employers. Consider strategies for preventing and responding to discrimination and harassment, and then looking at abusive workplace conduct, which can encompass many different things. So what is the effect of harassment in the workplace? There's, beyond just the illegalities of it. When you're looking at the functionality of a workplace, it can have huge ramifications. So you're looking at increased absences, low productivity, general low morale, interpersonal conflicts, and of course the legal ramifications. So this is just to say that the effect reaches beyond just the civil liability. So as I said, this is a required training. So California requires all non-supervisory employees to engage in 1 hour of training per year, and then supervisors must participate in a 2-hour training. So this particular training will go until noon with a break in the middle. All right, so what is harassment? Regulations define harassment as several different things. So it can be verbal harassment, it could be physical harassment, or it could be visual harassment. Verbal harassment, you're talking about the classic, epithets, derogatory comments or slurs, or repeated romantic overtures, sexual comments and jokes, or prying into one's personal affairs. Physical harassment is the unwanted touching, the rubbing up against someone, and then full-blown assault, and then physical interference with movement or work. This one, the physical interference sometimes can get a little bit confusing. The classic example that I've used is someone's trying to leave the room and another individual is blocking the doorway and refusing to get out of their way. That can be a physical harassment, even though there's no touching of another person, but there is this physical interference with the individual's ability to leave the room or to do something. Visual harassment, this is things that people can see, right? So cartoons, drawings, posters, gestures, facial expressions sometimes, leering, which is, facial expressions, staring, that kind of thing. All right, so first we're going to talk about the legal implications of harassment. So when we talk about liability, we're talking about two different kinds. We're talking about the harasser themselves, and then we're talking about the employer. And when are each of those individuals or entities liable for harassment? So the employer is going to be liable to a victim of harassment if the harasser is a supervisor, or if the harasser is a non-supervisory employee and the employer knew or should have known of the ongoing harassment. So the important thing to remember here, and we're going to go over this several times, is that the employer is always going to be liable for harassment that is done by a supervisor. Now, that is called strict liability. You'll hear that term several times, but that's that strict liability. No matter if the employer knew it or not, the employer could be completely oblivious that the supervisor is acting this certain way. Doesn't matter, it's a supervisor, the employer's liable. And that's different for a non-supervisory employee. At that point, the employer must have known or should have known that this was going on in order for liability to happen. And now I skipped that first bullet, but it's important. The harasser themselves, no matter if they're supervisor, employee, anyone, they're always going to be personally liable to the victim for that harassment. Every person in the workplace, whether you're a supervisor, subordinate, coworker, that is found liable for sexual harassment is personally liable, like I said, and they are responsible for damages caused by the unlawful harassment. And we'll get into damages later. And it also may rise to the level of a crime under the penal code rather than in the civil context, which is mostly what we're talking about today. So both federal and state law prohibit sexual harassment. There's a lot of overlap between the federal and state law, but there is some key differences that we're going to look at. So first, who's protected by the law, both by federal and California? And now if you look, California is on all of those categories: employees, applicants, contractors, volunteers, unpaid interns, essentially anybody that is in the building of your business is protected by these laws. That is not true under the federal law. Federal law only protects employees. But we're in California, so everybody in the building is protected under California. So the federal law at play here is Title VII of the the Civil Rights Act, which is a federal law. It makes it unlawful for an employer to discriminate against any individual with respect to their compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So that those are the specific categories of protection under the federal Civil Rights Act. State law, California Constitution, first and foremost, protects against employment discrimination and harassment by both public and private employers on the basis of sex, race, creed, color, and national and ethnic origin. So that is what is specifically stated in the Constitution. But California goes one step further and has the California Fair Employment and Housing Act, commonly referred to as the FEHA. And this is a statute that is designed to prohibit sexual harassment, discrimination, and retaliation in employment. So through the FEHA, the state is able to even further expand the protections beyond federal and beyond the California Constitution. So the Fair Employment Housing Act specifically prohibits harassment and discrimination. Harassment is conduct outside the necessary job performance for personal gratification, meanness, bigotry, or any other personal motive. The motivation does not need to be motivated by sexual desire. That can sometimes come up when people say, well, I didn't mean it that way. Or, that was not my intent. Like, well, your intent really doesn't matter in this context. So this is extended protection. So the FEHA protects those independent contractors, the unpaid interns, volunteers, as well as employees and job applicants. So that's where that expansion that I was talking about comes from. The employer's duty, this is a huge difference that I want to point out. The employers must take all reasonable steps necessary to prevent discrimination and harassment from occurring. Employers get hit with this very often. We'll talk about this when it comes to like investigations and things like that. But if an employer can't show that they've taken all the steps that they possibly could to stop this from happening, if they become aware of it, or to try to prevent it from happening, they will be liable. Just a note, the Fair Employment and Housing Department, that used to be their name a couple of years ago. They changed their name to the Civil Rights Department. But the Fair Employment and Housing Act, so the FEHA, is still referred to in this way. It's just being enforced now by the Civil Rights Department instead of the Fair Employment and Housing Department. Okay, so this is just kind of saying what we've talked about already, but in a little bit different way. So FEHA, this extended protection to all of these different people. It's important because it's California specific. The FEHA, again, all reasonable steps necessary to prevent discrimination. Okay, so Government Code 12940A prohibits discrimination based on an individual's status as a member of a protected class. So, there's many protected classes under the FEHA for purposes of discrimination. But it's important when we're dealing with these kinds of claims to look at, is the behavior that the employee is complaining of linked to a protected class? Are they being treated this way because of their membership in one of these protected classes? And that seems like a simple question, but it's not always that simple, because you have to be able to show that it's specifically, the treatment is specifically because you are a member in one of these classes. So I think, yeah, here we go. This is better. So there are 17 sort of recognized protected classes under the FEHA. I won't go through them all. Some of the more common ones we see, race, sex, sexual orientation, religion, age, and disability. Those are probably the most common that we see complaints of, but there are a total of 17. Okay, just want to make sure there's no questions so far. And if you do have a question, go ahead and put it in the Q&A. It may take me a minute to get there, but I will try to periodically look at that. All right, so discrimination refers to a bias in the exercise of personnel management authority on behalf of the employer. So, you're treating one type of person or one class of people differently than another class of people or another person. And that disparate treatment is and that's poorly worded, but the reason for the difference in treatment is linked to one of those protected classes. So, is the employee being treated differently and negatively because of their protected characteristics? So, my supervisor treats my coworker who's a man differently and treats me differently because I'm a woman, and I can show that I truly, truly believe, and I have evidence that it is because I'm a woman, not because he's better at his job than me. That's the connection that you need there. So this is the specific, what we call prima facie showing. So this is the minimum that a plaintiff or an employee needs to show in order to have a successful claim for discrimination. So 1, protective is a member of a protected class, any one of those 17. Plaintiff was qualified for the position sought or was competently performing in the position held, so satisfying legitimate expectations. And then plaintiff suffered an adverse employment action, whether that be termination, demotion, some sort of reprimand. And then there's a causal connection between that discrimination and the adverse employment action. And we're going to talk about what that means. But all 4 of those things need to be met in order to move forward with the claim in court. So we're going to, the answer showing, which I didn't want, but that's okay. We're going to go through an example here. So a white male supervisor was deciding on a promotion. A supervisor told others that an African-American female employee was not interested in the position because of family commitments, which was not true. Supervisor promoted a less qualified white male employee. Plaintiff provided statistical evidence showing that the company had never promoted any African-American employees in their history, and further, that less qualified male employees regularly receive more promotions than qualified male employees, or female employees, excuse me. The question is, does female have a case for discrimination? And in this case, likely yes, on both sex and race bases because they could show the correlation between that protected class, their membership in that protected class, and the fact that they didn't get this promotion. Now, here's a different example, similar but a little bit different. So a female applicant applied for a position in the neurology department at a university. 21 others applied for the position, and the applicant did not get the position. Applicant was told by the university that there were several applicants. Many were reputable in the field of neurology, competing for the job, and the competition for the position was intense. The position required experience managing high-level research programs. The applicant had recently earned her doctorate, but did not have this experience. Department hired a male for the position, coming from another university where he had a similar position. The applicant provided statistical evidence to show there were no females in the neurology department at the university. And then the question again is, can she succeed in a gender discrimination claim? Here, the answer would likely be no, because it could be shown that her not getting the position was based on qualifications and not her sex. So if this was an entry-level position, and she had either more experience or a better resume, and she showed that the department had not hired a male in some years, then the conversation would be different. But in this case, there was clear reasoning why the other applicant got it. It had nothing to do with sex. So that's kind of an example of where sex would not be the basis. All right, so moving on to sexual harassment specifically. So what is sexual harassment? Sexual harassment is a form of discrimination based on sex and gender, which is unlawful under California and federal law. So it's really just bolstering this discrimination concept with it being very specific to sex and gender. And then there's additional rules when it comes to sexual harassment, discrimination based on sex and gender. So in California, sexual harassment includes harassment based on sex, which includes pregnancy, childbirth, or other related medical conditions that are specific to females, or not even females, specific to a certain gender, gender identity, gender expression, or sexual orientation. Okay. Again, liability. The individual harasser is always personally liable for the damages caused by their unlawful actions. Personal liability means that you could be, as a harasser, personally responsible for compensating the victim from their own personal assets, such as bank accounts, home, automobile, any assets that that individual has could be on the hook. And liability of the employer. Again, we went through this, but it's very important. An employer is always going to be strictly liable for the unlawful harassment of its supervisors. It's immaterial whether the employer was aware or not. And employers can be liable for harassment by non-supervisory employees if the employer knew or should have known about the harassing behavior and failed to take immediate and corrective action. So in what instance could an employer should have known? They're going to say, well, I didn't know. No one complained to me. I wasn't told anything. There were no claims filed. They didn't go to HR. Those would be examples of that they knew. But examples of when they should have known could be, a supervisor or an owner, or, the employer witnessed something or heard a rumor about something, or, became aware that there was, discontent among the employees and failed to investigate those reports, that kind of thing. So it's not overtly being told to them, but there are reasons that we could point to that say, hey, you should have known something was amiss here and you should have done something to, at the very least, investigate and see if there was something bigger going on. All right. Now this is the federal, so that was state. The liability of the employer for federal, the employer knew or should have known that the harassment was taking place and failed to do anything about it. And that's true for whether the harasser is a supervisor or just a non-supervisory employee. So that strict liability is not there for the federal law, which really doesn't matter in California. Again, that's more state by state on that. So what's a supervisor? Sometimes this can get a little bit confusing if you don't actually have a title that implies supervisory role. That doesn't necessarily mean that they're not a supervisor. So a person qualifies as a supervisor for purposes of the California Fair Employment Housing Act if they had the discretion and authority to any of these three areas, right? If they are able to hire, transfer, promote, assign, reward, discipline, or discharge other employees, or even if they don't have the actual authority to do that, they have this, they can effectively recommend any of these actions. So if they can recommend this to another supervisor or, a city manager, for example, and their recommendation holds weight, and it can be shown to hold weight, then that could qualify as the supervisor under the FEHA. Grievances. So if this employee has the authority to act on grievances of other employees or to effectively recommend actions on grievances, that would qualify as supervisor under the FEHA. Or if that employee has the authority to direct the claimant's daily work activities. So, if you're a shift lead, for example, and you're handling the scheduling, you may not be considered a supervisor in the traditional term, but under the FEHA, you could be. So, what does that mean? Supervisors, not only are the employers going to be liable for everything illegal that you do in this case, but you as a supervisor are responsible to take action if sexual harassment is reported to you or if they witness sexual harassment take place. So because you qualify under one of these three areas, you now have a responsibility to report anything that either that you are told or that you witness. And I'm told that there are some questions here. Let me go to that real quick before I move on. Okay. Statute of limitations for reported harassment. Generally, it's going to be 3 years. Can we get a copy of the PowerPoint? Yes, we can provide. Oh, Mario already said, but yes, we can provide the presentation. Do all harassment reports, even verbal, required to be forwarded to HR? Generally, that's a good rule of thumb to have HR involved. Is there a requirement? Not necessarily. If you were to report something to, let's say, your immediate supervisor or the city manager, they would still be responsible for making sure something happens. I always recommend having HR involved, but sometimes that's not always that's not always practical. It's rare, but sometimes the complaints are concerning someone in HR, and so you may want to keep HR out of a certain situation. But generally, HR should be involved, but it's not required. I think we are good on questions for now. Keep them coming. Like I said, I can't see them when they pop up, but Mario's kind of moderating that for me. All right. So kind of everything we've been talking about so far on one slide. So the differences between the federal and the California. I won't go through it all, not all of it, because we've talked about most of it, but some differences. So the federal law applies only to employers that have 15 or more employees. Rather than we look at California, it doesn't matter how many employees you have, the FEHA covers all employers, even if you just have one person. Yeah, and then the independent contractors, volunteers, unpaid interns, not covered under federal, covered under California. We did talk about that. Okay, so let's get into kind of the nitty gritty of situations where sexual harassment is happening. So there's two main forms of sexual harassment in the workplace. There's the quid pro quo, and then the hostile work environment. Quid pro quo is what I would say is sort of the classic example of sexual harassment that you see, in social media, in movies, in TV shows. This is a demand for a sexual favor in exchange for employment benefits, or demanding sexual favors by threatening some sort of negative action. And we'll go through those, but that's sort of the classic thing. In the movie, you get the old boss that says, okay, well, if you sleep with me, I will get you a raise or a promotion. Classic, but probably less common that we see in the workplace today. Hostile work environment is much more common, and it's more of an analysis of an entire situation rather than one fell swoop moment in time. So in a hostile work environment, you're looking at whether the plaintiff was subjected to verbal, physical, or visual, I should say, conduct. That conduct was unwelcome, and the conduct was sufficiently severe or pervasive as to alter the conditions of the victim's employment and create an abusive working environment. We're going to talk about what that means ad nauseum, but that last bullet is always the crux of a case. It's usually easy to show some sort of conduct and that it was unwelcome, but in order to be successful, you need to show that conduct was sufficiently severe or pervasive. And that's where things tend to fall apart in the legal realm. Just a kind of a side note, a claim of sexual harassment can establish the outrageous behavior element of a cause of action for an intentional infliction of emotional distress. So a lot of times what we see with employees that claim sexual harassment, they also claim this intentional infliction of emotional distress, which is a separate civil claim, but it is fulfilled by this outrageous behavior element that can be established by the same conduct that would constitute a sexual harassment claim. Hope that makes sense. That was a little bit of word salad, but I think that explained that. All right. So quid pro quo. So simply put, quid pro quo sexual harassment claim is when a supervisor relies on his or her apparent or actual authority to extort sexual favors from an employee. So this threat may be expressed or implied. So what I mean by that is it could be specifically said, hey, you do this, I will do this. Or it could be implied by actions rather than actually verbalizing it. So typical quid pro quo sexual harassment involves some form of sexual advance or proposition by a supervisor with an express or implied threat that if employee refuses, they will be terminated, demoted, lose other job-related benefits, or alternatively, the employee may be promised better treatment, such as promotion, transfer, raise, or favorable recommendation if the employee submits to the sexual advances. So just kind of putting that in more of a context. And I know it says supervisor, but it doesn't have to be supervisor, and we'll talk about that too. It can be anybody at the workplace can be doing this. All right. Quid pro quo examples. So, female employee was asked to lunch by her supervisor to discuss her yearly performance review and consideration for promotion. Employee expresses clear interest in the promotion. Supervisor suggests that he will put in a good word for her with the committee making the decision if she agreed to his sexual demands. This is going to be that classic express quid pro quo, absolutely all day long. That's what this is. Now, with the second example, it's a little bit different. Employee and supervisor began having sexual relations. Shortly after the relations began, employee is given a promotion with a higher salary. Employee informs supervisor that they will no longer be engaging in sexual relations with them. The employee is promptly demoted back to the previous position without any explanation. So here we have a correlation. We have this timing aspect, right? Right after the sexual relations stop, some sort of adverse employment action was done, meaning the demotion, but it was never said. There was no expression of this demand. This is the classic implied quid pro quo example. It can be implied by the fact that she got demoted right after the sexual relations ended, that it was tied to that. And then it becomes the responsibility of the employer to show that it was based on something else. All right. So remedies for sexual harassment. We have injunctive relief. So this is a court order requiring the employer to either stop some action or take some action. There's economic damages. This is the most common. Lost wages, medical expenses, job search expenses. If they went to see a therapist, or if they went to, they left work because they couldn't be there, so they lost wages, that kind of thing. And then the most, I'll say, common or kind of the big driver in these cases are non-economic damages. So that's this emotional distress, this loss of enjoyment of life, things that are hard to quantify go into this category of non-economic damages. And that's where you see these huge numbers coming out of these cases are always going to be in these this number 3 section. And then punitive damages as well. These are less common, but punitive damages are intended to punish. And so it's just sort of another award on top of everything else, saying, it was so egregious, you should be punished beyond what you're already paying. And that they do qualify for that. All right, so moving on to retaliation. Okay, retaliation is prohibited. It occurs when an employee engages in protected activity, is subject to an adverse employment action, and then a connection exists between the two. So, what is a protected activity? This is some examples, really, but a protected activity is refusing to obey an order that is discriminatory, filing an internal complaint regarding unlawful activity, testifying or cooperating with a state or federal agency, or other similar conduct. I will say the most common retaliation protected activities that we see is an internal complaint of some kind, whether that be a complaint to HR or to a supervisor of either another employee or of some other illegality that's going on. Whether you're saying, I think the finance department is laundering money. If you have an true belief, a reasonable belief that is happening, you can't just say that with no reasonable belief. But if you have a reasonable belief that's happening, and then something happens to you after you bring it to someone's attention, that's going to be a protected activity. It's an extreme example, but that is kind of what we're talking about, that kind of action. So what is an adverse employment action? An adverse treatment is something reasonably likely to impair a reasonable employee's job performance or prospects for advancement. This is distinguished from minor or relatively trivial actions that are likely to do no more than displease. So we see this reasonably likely or reasonable employee. This reasonableness standard is what it's called. It is across all of civil law. It's based upon what a normal person in this situation under the circumstances would either do or think. It's very subjective. It's supposed to be objective, but it ends up being very subjective, and that's where a lot of issues arise. But you'll see that standard a lot, this reasonable employee. So some examples of adverse treatment: verbal abuse, a denied promotion, denial of overtime, denial of benefits, intimidation, reduction in hours. It could be demotion. It could be a reprimand of some kind. All of those things would qualify as an adverse action. And now this timing element is very important. So the connection between the protected activity and the adverse employment action. So this connection is made up of two things. It's timing and employer knowledge. So timing, the protected activity. So let's just say this a complaint from the employee. Okay, just so it's easier. So this complaint, and we'll go with the demotion, and the demotion must be close in time that they are related. So the complaint filed against the boss and demoted the next day, not 6 months later. So it needs to be close in time enough to show that they are correlated. The other part is that the adverse actor, so in this example, the boss, must also know that the protected activity had taken place. So, if the boss didn't know that there was a complaint filed before the demotion took place, then there couldn't possibly be a connection between that complaint and the demotion. Now, the employer is going to have to show that they didn't know, but that piece is very important as well. So retaliation from coworkers. If a plaintiff can show that harassment by coworkers followed plaintiff's complaint about harassment and that the employer had actual or constructive knowledge of the coworker's retaliatory conduct and either participated in or encouraged the conduct or did nothing to end it, then the harassment may constitute an adverse employment action for which the employer could be liable under retaliation theory. A lot of words. Really what that means is if an employee can show that they're being retaliated against by coworkers and that their employer knows that that is occurring and is doing nothing to stop it or sometimes even encouraging it, then they can be liable under the retaliation theory as well, even though the employer isn't actually retaliating. Sort of like that, knows or should have known type of standard for harassment that we saw. Okay, so what is not considered an adverse employment action? This becomes relevant all the time. So things that are usually considered not adverse actions are counseling, general criticism, negative performance review, a lateral transfer, a requirement to learn a new skill, or other trivial employment actions. But, it could be shown that a series of subtle yet damaging injuries could constitute an adverse employment action. It doesn't have to be a swift blow like a demotion or termination. It can be a lot of little things that happen. We're talking about this as like maybe this, maybe that, and that's true of these kind of claims. It's always very fact specific, very, based on the circumstances of each case. It's very much a case by case basis. And so you know, there's no one size fits all method for these claims. Okay, hostile environment sexual harassment. So hostile environment sexual harassment may involve various forms of verbal, visual, and physical conduct of both sexual or non-sexual nature, which have the purpose or effect of creating a hostile or offensive working environment. So to state a prima facie case for hostile environment sexual harassment, under either the federal or state law, plaintiff must allege that there was unwelcome advances, conduct, or comments, that the harassment was based on sex, and the harassment was so severe or pervasive as to alter the conditions of the victim's employment and create an abusive working environment. We've seen that very similar just a few slides ago. A lot of this is overlapping. All right. So, hostile environment. So, whose conduct may create the hostile environment? It could be supervisors, it could be coworkers. Clearly, conduct from the supervisors in the form of sexual advances, offensive sexual comments, or hostile conduct may create a hostile environment for employees. A hostile working environment may also be created by sexual conduct or remarks from coworkers. And also, the victim need not be the intended recipient of the offensive conduct. So, this is very this is kind of a niche area, but it does happen. So, vulgar and offensive email between two male employees concerning female coworker could be evidence of harassment, even though she was not the intended recipient of the email. So, if two individuals are emailing back and forth about another employee, not intending for her to ever see it, but she ends up seeing it, that could be hostile environment as well, even though that conduct was not directed at her. All right. So hostile work environment, sexual harassment. 3 varieties. Conduct directed at the claimant, conduct directed at others, and then widespread sexual favoritism. We'll kind of go through different examples of the verbal. I think these are a little out of order, but that's okay. Verbal harassment related to sexual harassment would be foul or obscene language, derogatory comments, explicit discussions about sexual activities, and comments about people's physical attributes. Visual, we talked about leering, staring, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffiti, posters, or sending graphic emails, text messages, or jokes. And then the physical, kissing, hugging, grabbing, impeding, or blocking movement, which we talked about, and just plain old assault. All right. Physical touching is defined. So, unwanted touching, a hostile environment sexual harassment claim may arise when there have been no outright sexual advances or propositions, but where plaintiff is subjected to unwanted touching. Example, supervisor or coworker intentionally and repeatedly rubbing up against plaintiff's body or touching them in an offensive manner. And generally, physical touching is always considered more offensive than mere words. And when I say more offensive, I mean really what we're talking about is the severe or pervasive standard. Physical touching is always going to be considered more severe or more pervasive than maybe some other examples of sexual harassment. All right, so the severe or pervasive, I told you we'd be talking about it a lot. It does not need to be both. So the victim does not need to show that it's both severe and pervasive. It just needs to be one or the other. Okay. So when you're looking at severe, I think we go over this in a little bit, but the severity you're looking at really, how often is this happening? How bad is this conduct? Whereas pervasive looks at, more at frequency. It looks at, how is this really affecting the workplace? Is it, I can't think of another example right now, but we're going to go through in a second. I always get questions about the difference, and really there's not a huge difference, but the law likes to make things more complicated than it needs to be. So psychological harm. So plaintiff does not need to prove the psychological injury to maintain the sexual harassment action. And the hostile work environment does not require a diagnosis of a specific medical issue. So you don't need to show, I now have anxiety, I now have depression. That is not a requirement. Okay, so we've seen this unreasonable interference with working environment in some of these prima facie elements that we've looked at. So it is generally a question of fact whether the harasser's conduct was severe or pervasive enough to alter the work environment. And when I say a question of fact, that means that it is a decision for a jury to make. So there's questions of fact and questions of law. Questions of fact go to a jury. Questions of law go to the judge. So isolated incidents, even if highly reprehensible, may be deemed insufficient as a matter of law. So hostile work environment considers all of these factors. So it considers the nature of the unwelcome acts or words, the frequency of the offensive acts, the total number of days over which all of the offensive conduct occurs, the severity of the conduct, whether the conduct is threatening, and the context in which it occurs. Now, these are factors, not elements. Elements are things that all need to be met. Factors are things that are all just considered and weighed together. These are factors. Right. So when we're dealing with hostile work environment, then adverse employment action is not required. So we talked about all those adverse employment actions, demotion or a reprimand, things like the termination. You don't need to have that in order to be successful in a claim for hostile work environment. Complainant does not have to have a tangible economic loss or any other employment action, adverse employment action. The crux of a harassment claim is that there's some sort of assault on the complainant's personal sense of dignity and well-being. And so that's sort of the overarching idea behind a harassment claim. So the more incidents that occur, the less, quote, severe they need to be to establish hostile environment. To be deemed pervasive, the incidence of misconduct must be sufficiently continuous. So it has to do with length of time and frequency. Again, the abusive conduct does not need to be both severe and pervasive. One or the other will do. So isolated trivial incidents. So these are all, this is from case law that we include here. The court in this case said occasional, isolated, sporadic, or trivial acts are usually not enough to alter the conditions of employment and create a hostile environment. But, however, there's always the however. In some cases, a single incident may support a hostile environment claim depending on its severity. I know it's, kind of going back and forth, but that just shows how subjective this area of law really is. There is no black letter law in some of these things. So this is just kind of a graphic that goes through what we've already talked about, but it can be a little bit easier to see it like this. So sort of this balance, right? You're looking at frequency. Is it just annoying or uncomfortable? What's the severity of it? Is it threatening or humiliating? whether it's physically threatening or humiliating or a mere offensive utterance, whether it unreasonably interferes with an employee's work performance, but none of these single factors is required. Okay. Let me check. Okay, so I do have a question. Does the employee have to give a verbal warning to the person harassing them before filing a complaint? You know, you love this answer, but it depends. If the action is sufficiently severe, no warning is necessary. Now, in situations where actions are minor, so for example, someone comes up behind you and touches your shoulder, that in and of itself probably not going to be shown to be harassment. But if they come up to you, touch your shoulder, and you tell them, "Excuse me, it really makes me uncomfortable. Please don't do that again," and they continue to do that, then you have, even though those are relatively minor instances, but because you gave them the warning before and they continue to do it, that bolsters your claim for harassment down the road. So, but if it's much more severe action that was taken at the outset, you don't necessarily need to warn them. I hope that answers your question, Raquel. All right, so ethnic slurs by supervisor versus coworker. These are just kind of, I'll go through a couple of classic examples that you see in the workplace that have been specifically ruled on by courts. So even a single act by a supervisor may be severe enough to alter the conditions of employment. Thus, when a supervisor makes a single racial slur, it exacerbates the severity of the remark and may create a hostile work environment. So what the court really says here is, because the supervisor was the one to make a slur, the very fact that it's coming from a supervisor heightens its severity when you're looking at the severity of the severe pervasive analysis. The very fact that it's coming from a supervisor heightens that severity. That's really what that says. Because you have a higher expectation for your supervisors, they're held to a higher standard, inevitably. So the court in 2003, which is quite a while ago, but it's still true today, is perhaps no single act can more quickly alter the conditions of employment and create an abusive working environment than the use of a racial epithet by a supervisor in the presence of his subordinates. So that's where that idea comes from that court ruling. Okay. Workplace-related conduct. So the sexual act or the offensive conduct does not need to be committed in the workplace to have consequences there. So after hours counts. The Christmas parties, the weekend events, anything like that is still considered, workplace even after hours. Normal interaction between sexes. So simple teasing and offhanded comments do not amount to discriminatory changes in the terms and conditions of employment. This comes from that case there. If I don't want to try to say that, but from the city of Boca Raton. This we see all the time. We get clients that just don't really don't like their boss. Their boss teases them sometimes and don't like their attitude, and that alone likely will not be discriminatory because it does not change the terms and conditions of employment. The sporadic use of abusive language, gender-related jokes, occasional teasing is not actionable harassment. That's the exact quote there. And then also a single or rare microaggression would not normally amount to actionable harassment either. So what's a microaggression? A microaggression is a statement, an action, or an incident of indirect, subtle, or unintentional discrimination against members of a marginalized group. That could be race, gender, etc. So they're commonplace indignities. So normal, brief, and commonplace daily verbal, behavioral, or environmental indignities that communicate hostile, derogatory, or negative attitudes. I put some examples. You're aggressive for someone so petite. That could be a marginalized group of, usually petite, you're talking to a woman, or something like, you speak English better than I expected. That kind of a backhanded microaggression there, right? Based on race. Pet names, very common. Being a woman myself, in the job that I have, you get that a lot. Sweetie, honey, darling, sweetheart. And what's specific to microaggressions is the intent there. A lot of times they really have no idea that it's offensive, and it's not intended to be offensive. A lot of it has to do with generational commonalities, and it's something that needs to just be pointed out. Another example would be asking a woman her age, then looking at her ring finger. That one happens all the time. Yeah, I'm sure you all can think of microaggressions that you walk away from the conversation thinking, what did that mean? Or, what do they mean by that? Those are microaggressions. And before I move on, generally microaggressions aren't going to be enough to reach to workplace harassment. But if it's something that you point out to them and you say, it really bothers me, can you please try to do that? And then they intentionally continue to do that, or to say that, then you may have enough to have a claim. And that's where that analysis of the severe pervasiveness comes into play. But one-offs of these types of things are generally not going to rise to the level. Abuse is not gender-based. So sexual harassment can occur between individuals of the same sex. That's settled law for a very long time, but sometimes that can be misconstrued. It's like, well, I can't discriminate against a woman because I'm a woman. That is absolutely not how the law works. Sexual motivation, explicitly the FEHA states that sexually harassing conduct does not need to be motivated by sexual desire. The harasser's actual motive is completely irrelevant, whether that be misogyny, personal vendetta, misguided humor, boredom, lack of social awareness, all irrelevant. All right, before I get to this example, I'm going to check one more time for questions. Okay. All right, so Chantel works in sales at a retail clothing store. Her boss, George, is a gay man. George often comments on Chantel's body and breast size. Comments make Chantel uncomfortable, and she has asked him to stop, but he does not. Is this sexual harassment? So George's conduct is harassing, regardless of the sexual desire or motivation. It is a form of gender discrimination and can happen even if there's no sexual desire. So the fact that George is a gay man, it's what he's saying, not why he's saying. Another example, Warren is a supervisor of Jill. On 2 occasions, Warren pats Jill on the shoulder to congratulate Jill for a job well done. Warren also refers to Jill as sweetheart during these 2 occasions. Jill complains and files a claim with the DEF. Was Jill subjected to hostile work environment? No. Well, this was an actual case, and the court said no, not sufficiently severe or pervasive to alter the terms and conditions of her employment. Now, if Jill would have told Warren stop and he continued to do it, the conversation might be a little bit different. Which goes to Raquel's question. All right, so sexual harassment permeated plaintiff's workplace. So plaintiff must establish that sexually harassing conduct permeated her or his direct work environment. Male coworkers' daily use of bitch or slut and other crude language to refer to women. This was an actual case as well. Court said that the daily use of those words created a hostile work environment for the female worker. Co-workers' comments about female employees' buttocks and sexual relationships and crude gestures toward the female employee when her back was turned, the court said no, it did not create a work environment that was permeated with sexual harassment. And that one always surprises me, but I think the reason that that's important to look at that is something that, you know, may seem like it raised the level, and sometimes things seem like it wouldn't raise the level. You really don't know. It depends on the court. It depends on the jurisdiction you're in. It depends on the jury you get. It's really, really subjective and kind of a gray area. And so we'll talk about that. But it's always better to err on the side of caution on these things always, because you just never know what's gonna fly. All right. So plaintiffs aware of other harassment. Plaintiff generally must show that the harassment directed at others was in her or his immediate work environment and that they personally witnessed it. So there can be no hearsay. Plaintiff must present direct testimony that such harassment occurred by the victims or witnesses. Plaintiff cannot rely on hearsay or workplace gossip. So a hospital nurse claimed a staff doctor was harassing nurses in the operating room, but she did not work with him in that operating room. She would not be able to introduce evidence of his operating room conduct in support of sexual harassment claim unless she was also personally subjected to such conduct herself outside the operating room, which is a bit confusing. But so this nurse, could not just say, I heard that he treats people this way in the operating room. But she can say, he treats me like this outside the operating room. In addition to that, I've heard that he treats other people this way other places. But because she has also experienced something from this doctor, she can use that evidence. But without her own experience, she cannot. I think that's the best way to say that. I pretty much just said that, but on the other hand, one who has been personally subjected to sexual harassment may introduce evidence of harasser sexual misconduct toward others, of which she becomes aware during her employment, even if the other acts occurred outside of plaintiff's presence, but only if they themselves have also experienced something. All right, quick true or false. An individual employee may be personally liable for sexual harassment if they are the person causing the sexual harassment. I don't know if it, nope, okay. Say it to yourselves. That is true, always, always, always. Second, to prove hostile work environment, sexual harassment, the complaining party must show they were subjected to unwanted sexual attention that was both severe and pervasive. Look around. Say yes or no to yourself. That's false. Tricky one, but it's severe or pervasive. Remember, don't need both. And third, California law is broader than federal law in providing protection against sexual harassment. That is true always. All right. I thought we were coming up on it. All right. So this is the end of the supervisor portion. Excuse me, the non-supervisor portion. Supervisors stay on. We'll take a few minute break and come back. Thank you to the non-supervisories that participated.